All right. Hello, everyone, and thank you so much for joining us today for our guardianship webinar. My name is Sarah Beth, and I'm with the Council on Developmental Disabilities. And I have our assistant with us, Kelsey Edwards, who will be helping facilitate as well. And we are going to introduce to you guys Claudia Smith. She is going to walk you through what the guardianship process looks like, all of the fun paperwork that we get so overwhelmed with and are not sure what to do with. She's here to help us make that whole process a lot easier. We are going to make sure we put in the chat some information for you as far as contacts. If you have questions after, we're going to try to link some paperwork so you all will have an idea of what that looks like. At the end of this webinar, please be aware that we have a survey. We need you to fill that out. That way, if you have questions, comments, concerns, or we completely skipped over something that you needed, you can put that in the comments. We will look at that and try to provide additional information as we go, following up. And if you need anything throughout this, you have questions, please write them down, because at the end, we will take your questions and you can either be unmuted and ask them directly, or if you feel more comfortable, those in the chats, and we will go back and refer to those. But we cannot thank you all enough for being here today. The council strives to provide education to families of those in the IDD community and get out education the best way that we can to help navigate the craziness of all of our lives, because we know personally ourselves what it's like to care for someone with IDD. So thank you all so much for being here. We're going to turn everything over to Miss Claudia.
Hello, good afternoon. Before I begin, let me ask, is there any way that I can view the participants, or is it just the speakers that I'm able to view?
It is going to be just us.
Okay.
Mm-hmm.
I see that there's a raise hand function, so I'm assuming if that lights up that somebody will be able to tell who that is and allow them to speak.
Yes,
Okay.
We can do that at the end with questions, absolutely.
All righty. As indicated, my name is Claudia Smith. I'm an assistant Jefferson County attorney. I head up the mental health unit that encompasses the guardianship division, the mental inquest division, and the Casey's Law division. We're going to be talking about guardianship today, but just really quickly, the mental inquest division is responsible for handling those hearings where people are in need of involuntary psychiatric hospitalization. The Casey's Law unit is responsible for handling those cases where someone is addicted to alcohol or drugs and loved ones are extremely concerned about their health, safety, and well-being and want to get long-term treatment for them. We're here today about guardianship. I'm gonna give an overview of the guardianship process and how it works, and go through some of the forms that relate to the unit. And at the end of this, I'm going to ask you all to save your questions until then, and we'll take them one by one. At least I think that's how we want to do it, because I've seen a couple of raised hands already. How do y'all want to handle that?
Sarah's going to work on the raised hands right now.
Should I wait?
No.
Oh, okay. All righty. First of all, let's start with the definition of what guardianship is. It is a protective proceeding that our Kentucky legislature put into place to ensure that vulnerable citizens in our community are not exploited or abused. And the definition of what a vulnerable citizen is includes people with intellectual disabilities, mental illnesses, traumatic brain injuries, and dementias. Those are generally the four categories that we see coming through the guardianship unit on a regular basis. There are some outliers where someone is what we call functionally disabled, and that's actually the legal definition of what guardianship covers. But we classify functional disability as someone who is so debilitated that they really can't manage their own affairs, even if they have some capacity to still do it. So we don't handle those as often, because it's a really risky thing to sort of start getting into guardianship when somebody still has cognitive capacity. And by that, I mean the ability to sort of think through the steps that need to be taken to address their own personal and financial affairs. Those two categories of personal and financial affairs are what guardianship covers. They generally encompass, those two broad categories encompass the day-to-day activities most people must manage on a regular basis. The category of personal affairs includes the right to make living arrangements, and that means that the determination of whether you're in a nursing home or whether you have assisted living, or whether you're in an assisted living facility, whether or not you are in a senior high rise with somebody coming in to give you a few hours of assistance per day. Living arrangements has a wide range of possibilities. If guardianship is put in place, the guardian is in charge of making those decisions about living arrangements. The right to drive a vehicle is at stake in a guardianship proceeding, and it's generally classed under personal affairs. The right to vote is at stake. The right to make your own medical decisions is at stake in a guardianship proceeding, and that includes, simple doctor visits all the way up to major life-determining medical decisions. If a guardian is put in place over personal affairs, the guardian would manage those medical affairs. The category of financial affairs is usually self-explanatory, and it's also covered by guardianship. It encompasses the ability to write checks, to cash a check, to have a bank account, to transact business on a bank account. Also within the category of financial affairs, but it bridges over a little bit into personal affairs, but I think the court's firmly classed it under financial, is the right to make contracts and legal instruments and make a will. If a guardian is appointed for someone, they lose the right to transact business in those areas. And the guardian has the legal authority to make decisions in those same areas. When I say that a ward or a person under guardianship, that's what a ward is, loses the right to transact business, it means that they cannot make a legally valid contract if they're under guardianship. And technically, a hospital could be liable if they allow someone under guardianship to make their own medical decisions and it turns out to be a catastrophe, because the ward, by court order under the law, is not legally permitted to make those decisions. Now, the reason that guardianship is a really big deal is because it removes rights from the individual. And because it does remove rights from the individual, we want to make sure that it's only implemented or put into place when it's absolutely necessary. So guardianship is what we call the most restrictive method of managing another person's affairs. And when I talk about another person, I'm referring to someone who is at least 17 and a half years of age and older. Because it's so restrictive, we just don't want to take someone's independence away from them unless there's no other way to manage it. And so less restrictive alternatives are frequently considered as an alternative to guardianship. And the most common is power of attorney. And a power of attorney is something that everybody in this webinar should have in place for themselves, because at any given point in time, any one of us could go through a situation where we're not able to make decisions for ourselves. Heaven forbid, but car accident with a traumatic brain injury, that means that you're not in a position of managing your affairs. And if you haven't made pre-arrangements through something like a power of attorney, your family is going to have to seek guardianship from the court. And I tell my close friends and loved ones that you really don't want guardianship unless it's absolutely necessary. And that's because it's a governmental intrusion into your private life. And guardianship has lots of duties and responsibilities that some people consider burdensome. And it also leaves the final say of what happens in a particular case ultimately up to the judge, up to the court. Most of the time, the judge is going to go along with what a reasonable guardian wants to do. But there are instances where there is a disagreement about what needs to occur or what should occur. And in those situations, the court will weigh in and make the final determination. So guardianship shouldn't be considered unless there's no other alternative. Healthcare surrogates are out there. Most hospitals, when you're checking in to have serious surgery or something, will get you to sign a healthcare surrogate that says if you become medically incapacitated, then who's going to make your medical decisions for you? Some people who are getting Social Security have set up a payee relationship. That's another less restrictive alternative. So there are a number of circumstances out there where that can be used. Let me start over. There are a number of procedures out there that can be utilized to avoid having to go through guardianship court. But if you do have to go through guardianship court, there's a process that you must go through, and that's what I'm going to go over with you right now. The guardianship process begins with the filing of a petition, and a petition is just a fancy legal word for ask. And the petition for guardianship is one where the petitioner, the person filling out the paperwork, is asking the court to appoint a guardian for the respondent, the person who is in need of a guardian. So RESPONDENT is the legal term for a person who is alleged to be in need of a guardian. Once the guardianship hearing has taken place and a guardian has been appointed, we call the person who has a guardian a ward, W-A-R-D. And, you know, I always tell people, you hear all these people, reciting the phrase ward of the state. And people are terrified of that phrase because I think it makes them sort of bring up the sort of Dickens idea of being in some kind of, gray, big, gloomy room chained to the bedpost and getting gruel for dinner. Well, being a ward of the state simply means that instead of a family member or a loved one being your guardian, you've got a state social worker who's your guardian. And just because you have a state social worker doesn't mean that you're going to be institutionalized. Sometimes wards are living with their family members, and the family member just isn't up to the responsibilities of the reporting for guardianship. And all they want to do is just take care of their loved one. So they'll turn the business aspect of guardianship over to the state and let the state social worker do it. And they just love and care on their loved one in the home. And there's never any consideration of potential institutionalization. So ward of the state is just a phrase that's just gotten blown out of proportion. But anyway, filing guardianship requires you to get a packet of paperwork from the Jefferson County mental health clerks. The mental health clerk's office is located in the Hall of Justice at 600 West Jefferson Street. Their office is on the 3rd floor. The room number for the courthouse is 3177. That information is printed on the paperwork from their office. I say that, but it may not be. But their phone number is 595-4053. They house the mental inquest and the cases law unit as well, just like our unit does. It's all housed in one section. They have a packet that is unique to Jefferson County. And I emphasize unique to Jefferson County because if you go to Bullitt County, they have a different set of paperwork. If you go to Shelby County, Oldham County, they all have different sets of paperwork because the methods of handling cases differ from county to county. I will tell you that Jefferson County has the highest volume of guardianship cases in the entire state. So I may be a little prejudiced when I say that I think our process is streamlined and very efficient at getting all the information that we need in a sort of concise fashion. We do utilize forms that the state prints for us. I will say that any confusion that occurs is usually a result of the state forms. And I'm going to go over those state forms with you and sort of explain some of the confusing bits to you. You can get a packet of information, a guardianship packet. We call it a regular guardianship packet that distinguishes it from an emergency guardianship packet. which I don't think I want to get into here with you. I may say a little bit more about it briefly later on, but let's focus on guardianship. But a regular guardianship packet can be obtained from the clerk's office. You can give them a call. I think that they're willing to email it to you, or they'll snail mail it to you. Or if you want to, you can go by and pick it up in person. Once the packet is completed, it's going to cost $100.50 to file it with the mental health clerks. They do not accept personal checks. They will accept cashier's check. They'll accept cash, money orders, and debit cards. If you use a debit card or a credit card, there's a $2 or $5 fee, depending on which one you use. And I and the clerks ask very nicely that you all print legibly or type these forms, because we do have to read them, and it is amazing to me how difficult sometimes it is to parse out what is actually being written, okay? So the first form in the packet that you're gonna come across or the first page is going to be a cover sheet. And this is, well, I can't show it to you. It's going to be a cover sheet. And it's got a short form of instructions on it. My unit, specifically me, I am working on revising the instructions, expanding them, and making them a little bit more understandable for the public, so that they don't encounter much difficulty in completing the forms, this form on their own. But there's going to be a personal identifier data sheet that's going to be asking for information about the respondent, the person that needs a guardian. It's going to ask for their sex, race, date of birth, height, weight, eyes. That means their eye color, hair color, social security number, driver's license number, and what state the driver's license is in. We ask for this information and a piece of proof of social security number to make sure that we have identified the proper person. As I have mentioned before, the right to vote and drive are at stake. That information, when it is lost, when a ward loses those rights, it's reported to certain state agencies. And the right to own a firearm or possess a firearm is lost if you are deemed to be in need of a guardian. And again, that's reported to a state and federal agency. So, and to ensure that we're not removing the rights of the wrong person, we ask for proof of social security number. And proof of social security number, the best proof is the social security card, but we will accept things such as a face sheet from a hospital. Now, a lot of times the hospital will not release that information to you, but they will frequently, almost always, be agreeable to faxing it directly to the clerk's office, because they know what it's being used for, and it's not a violation of HIPAA for them to give it to the court system for, law enforcement purposes. And that's what this would be classified as. Letters from Social Security often prove to be sufficient if it actually has the number printed in it, but you can't write the number on a piece of paper and then go in and say, hey, this is proof of their Social Security number. It has to be an official document prepared in the course of business, or the actual Social Security card. The next page is the actual petition for guardianship. It's labeled petition to determine if disabled. In the upper left-hand corner is an AOC number, and that's how the court system refers to these forms. And the AOC stands for Administrative Office of the Courts. That's the office that carries out the court duties under the Chief Judge of the Supreme Court. And they're the ones that come up with what the content of these forms. I don't always agree with what they're putting in there. And I'll let you know where I think that it's confusing and what you might be able to do about answering the question in those circumstances. All righty, but this is labeled AOC number, form number 740, petition to determine if disabled. It's going to say the Commonwealth of Kentucky, and this isn't a confusing point, it calls us the petitioner, because that's who I represent as an assistant Jefferson County attorney. I represent the Commonwealth of Kentucky. We are actually the petitioner before the court, in the courtroom. You are the petitioner in terms of the paperwork because you're the one filling it out, making the request for guardianship. Once it goes to court, we pick up the petitioner role and carry it in through the legal process. So that first petitioner is going to already have Commonwealth of Kentucky print right beside it, but it's going to have a blank where it's asking for the name of the respondent. Please print the first name and then the last name. We have a lot of foreign names. I hate using the word foreign, but we can't always tell which one's the first name and which one's the last name. So if you want to help us out by indicating that, that would be very great. That would be appreciated. It's going to ask who it is that's filing for guardianship that has reasonable grounds to believe that somebody needs a guardian, and that would be the petitioner, the person that's filling out the paperwork. And then number one is going to ask for the petitioner's information, name, address, and telephone number. If there are alternate phone numbers, then go ahead and put those down too. It surprises me the number of people that put down their home phone number when they never use that phone and they really don't even check the messages on that phone, and they're not home, so you can't reach them. The purpose of getting the petitioner's information is so that we can be, the court system can be in contact if necessary, and it will be necessary, so that this process can unfold smoothly. So a primary number and an alternate number would be great. Number two, ask for that same information, name, date of birth, and permanent address of the respondent, the person who's in need of a guardian. It asks how long they've been at that address that you've listed above. And it asks if it's a facility, it asks if the address that's listed above is a hospital, nursing home, or facility. Number four, which is confusing because it's already asked, are they in a hospital, facility, or a long-term facility? It asks, is it a permanent address or a temporary address? Just answer whichever it is. There are some questions here related to the citizenship of the respondent, whether or not they've been convicted of a violent offense or a sex crime. And that relates to, you still need to answer it, but that relates to state guardianship. They are not required by law to accept cases where those facts exist. There's a history of a violent sexual offense or a violent offense in and of itself. The way that, I'm assuming that since you all are here, you're here for a loved one, and the state guardianship office would not be involved in your circumstances. But if by chance they are, there's a procedure whereby you have to get approval of the state guardianship unit to address or manage the guardianship case. So becoming a ward of the state is not an automatic thing. In other words, they're picky. They can decide which cases they're going to accept and which cases they're going to reject. So if it's necessary to consider a state guardian, the mental health clerks will direct you through the process of what that entails and give you contact names, paperwork that needs to be completed. Number 8 is the very important section of the petition to determine if disabled, petition for guardianship. And that asks for the nature of the respondent's disability and the facts or reasons supporting the need for determination of disability. They use the word disability here. I really don't like that phrase because it makes people think of Social Security, and we have absolutely nothing. I mean, literally nothing to do with Social Security. I would say, I would have phrased this, the nature of respondent's impairment and the facts or reasons supporting the need for guardianship. But what you're going to want to list here is the impairing diagnosis, and there usually is always a diagnosis. So intellectual disability, developmental disability, and you can put an IQ down if you want. And then you're going to indicate what they're unable to do for themselves as a result of that impairment. They cannot manage their personal affairs or their financial affairs as a result of their impairment is the most concise way to detail what needs to be put in this section. If you just put down intellectual disability or developmental disability, it's not going to be sufficient for this paperwork to be sent through the system. It's going to have to be modified. And that's because, intellectual disabilities fall within a range. You have people who are extremely high functioning or extremely borderline who would not be eligible for guardianship. They might need a little help with some things, but they're perfectly capable of managing their own lives independently without the need of court intervention. So if you just tell me they have an intellectual disability, I'm not going to assume that they are unable to manage their affairs just based on that. You can put things down like, they can't count, they can't, they don't recognize the value of money and can't identify coins or dollars. They need assistance with their activities of daily living and couldn't manage making any decisions on their own independently. In other words, you can expand on it, but the bare bones description would be they have dementia, and as a result, they're no longer able to manage their personal financial affairs. They have schizophrenia, a mental illness that means that they're unable to manage their personal financial affairs. So that's a bare bones answer that can be expanded upon. Number 9 is asking about the value of the respondent's estate. What cash and assets do they have on hand in a checking or savings account? What is the total amount of their yearly income, whether it be from Social Security, a pension, a trust fund, added together, what is it? Do they have a house? Do they own rental property? Do they have automobiles? You need to add all their personal property together and put the figure here. You need to add all of their real property and put the figure here. And it also asks what the source of their, or source says, of their yearly income is. So you're going to put the yearly income amount and then break it down for the court and explain where that money's coming from. The reason this question is being asked is because the court has to set a bond. When you are managing somebody else's finances, there is always a risk that it's going to be mismanaged or flat out stolen. And we have seen that before. I understand that everybody in this group is probably very loving and probably giving more to their loved one than their little monthly check even covers. But still, the law requires that every case have a bond put on it. And the bond is where the court can assure that the ward is going to be repaid if there's mismanagement. And it's just a matter of how they're repaid in determining how the bond is set. So with corporate surety means that you have to go to an insurance company and get bonded. And there's a listing of insurance companies in this guardianship packet that details these insurance companies that are very familiar with guardianship bonding. So with corporate surety, and what the judge is going to do is add up the liquid assets. That means excluding the land, houses, real property, and personal property, the stuff that's in the house. The judge is going to add up the liquid assets and the yearly income and figure out a bond amount. When somebody is on Social Security, we generally set the bond amount at $10,000 without corporate surety. And that means you don't have to go to one of those bonding insurance companies to get approved for a bond. It means that you're personally saying it's going to come out of my money and my assets if the court finds that I mismanaged or stole this money. Usually when we do without corporate surety, it's because the yearly income is so minimal that it's probably costs more to house them than their monthly check. So, all right, on the back page, it asks for number 10, the name, person, or facility having custody of the respondent. I think that's a dumb question because, the front page already asks stuff like, is this a temporary or a permanent address? If it's temporary, give us that address. It's a little redundant. Number 11 asks, is there already existing a power of attorney? I don't think that this is going to be the case with your loved ones, because we usually see a pre-existing power of attorney when somebody has dementia or a traumatic brain injury. But guardianship is necessary because for some reason, the power of attorney is not doing enough to address the needs of the respondent. But we always want to know if there's a healthcare surrogate or a power of attorney, you have to list their name and address. It doesn't ask for it on this form, but we like to have the phone number as well. It also asks for next of kin of the respondent, and that means that anybody on their level and up, or anybody that's extremely involved in their lives that may be extended family. So if you're a parent that is filing for your child and they have siblings that are over the age of 18, you would list their siblings. If they have a parent that is not in the household, or even if they are in the household, you have to list both parents. So next of kin is who is on the respondent's level in terms of relationship, and then it goes up the tree. I don't know if I explained that clearly, but if I didn't, you all can certainly ask me questions towards the end. All right, the bottom of this form, oh, you can attach separate sheets of paper if your list of next of kin is longer than the two little blanks that they give you here. I guess they don't contemplate anybody having more than two relatives. The form closes by saying, hey, by filling out this paperwork, we want to explain to you that what you're starting is a process. It's going to involve a trial. It means that the respondent's going to have counsel that's going to represent them, and that the court's going to appoint an evaluating team that's going to go out and see the respondent to determine if they feel that the respondent needs a guardian. And then it asks you to sign off on that. Many people don't understand what that means, but it's just essentially saying, this is starting a process, whether you realize it or not. We want to make sure you're informed. All right, it also asks for your signature, and you can have your signature witnessed in front of a notary, and there's a notary box at the bottom, or you can wait and sign your forms in front of the clerks of the court. The clerks of the court have the authority to sign off on your signature so that you don't have to go to a notary. Until May 1st, which is just a few days away, the clerks are still allowing people to waive the notary requirement. And they did that for about a year. And in the white box section of the notary box, you could just write waived due to COVID. But like I said, that's about to end. It's going to end on May 1st that waiver is allowable. Now, when you file a petition for guardianship on someone, you're agreeing to make yourself available to the evaluating team to the degree that they need to discuss the background and history of the respondent, to find out, where they're physically located, to facilitate them meeting with the respondent. And you're ultimately responsible for bringing them to court or making arrangements to bring them to court if they're required to be there. Many times our respondents are excused from attending, but the medical doctor that evaluates pursuant to the court order is the one that determines whether or not they can be required to come to court. Now, we've been doing all of our hearings lately by Zoom. Everybody loves it. COVID has so many negative, consequences and realities. But one of the things that has occurred is people realize that all this to-ing and fro-ing is not always necessary. So everybody loves the Zoom guardianship hearings. And so it's easier to make the respondent available when you don't have to shift them and get them all gathered up and, transport them down to the courthouse. So who knows what the future holds about whether or not Zoom will still remain a possibility for our hearings. I haven't heard anything about that yet. But if the respondent does have to attend, the petitioner is the one that has to make sure that they're available. There's a page called Designation of Process Agent. And Essentially what that is if you live out of state and you're applying for guardianship in Kentucky, we have to be able to compel your presence before the court. And legally, we don't go through the hoops of actually serving you out of state. We'll mail you something out of state, but that's not sufficient legal notice to get you into court. So what we make you do is we ask you to select somebody who does live in the state of Kentucky to serve as your process agent. That's the person that the court's going to send their legally binding notice to, and they're under the obligation of letting you know when you're compelled to respond or to the court or be before the court. And if you fail to respond or come before the court, the judge will remove you as guardian. You have to stay available and accessible to the system if you're going to serve as someone's guardian. The next page is about transportation options. That means that if you yourself can't physically transport the respondent for some reason, there are things that you can do and arrangements you can make to try to get them there. I've never, ever in my 12 years of being in this unit heard of anybody using any of these services. And usually if somebody's in a nursing home, the nursing home's going to make arrangements to get them there. If it's in a tense family relationship, then usually there's somebody else in the family that will be able to get them there. But if it's necessary, those options are within the packet. So that's the petition to determine if disabled. If you're asking to be appointed as someone's guardian, there's also within this packet something called an application for appointment of fiduciary for disabled person, and that's AOC form 745. And what this is, okay, the petition to determine if disabled is essentially saying, hey, Kentucky authorities, I'm raising the red flag that there is a vulnerable person in our community. That's all the petition is alerting the system that there's a concern here. You're the petitioner because you're bringing that concern to the attention of the court. This application for appointment of fiduciary is literally where you're saying, since they're vulnerable, I want to be the one that is in charge of taking care of their decision-making and their affairs for them. So this front form says the Commonwealth of Kentucky again, that's list us as a petitioner. You're gonna list the person in need of a guardian as the respondent again. And then comes now, it'd be your name, your application for guardian. And then your relationship is mother, father, sister, brother. And your qualifications are, I love and care for them. I've taken care of them all their lives. I keep my own bank accounts without a problem. Whatever you think qualifies you to be the person that's appointed as guardian is what you put in number 3. Number 4, it says you're offering as surety the following. And most people just put in that section as the court requires. Number 5 is a repeat of the same financial information that was on the petition. It's asking for the ward's real property value, personal property value, yearly income amount, and the source of the yearly income. Again, this is for bonding purposes. I have no idea why the Administrative Office of the Courts, AOC, decided to put it in 2 separate locations related to the same information. It also asks if you're asking for the cabinet to be appointed, and it indicates that separate paperwork has to be attached. It also asks you to sign off on the information that you filled out. Again, the signature either has to be notarized or signed before the clerks. On the back of this form, it has something that is really confusing. It's called a waiver of notice and a request for appointment of fiduciary. I'll tell you candidly, you just need to draw a line through that and not even worry about it. There are circumstances where family members can get together and agree that they want a particular person in the family appointed as guardian, and that they as a family member don't feel the need to be involved in the court process. They aren't concerned about the court process, and they're nominating their relative who is applying. In other words, they're co-signing or endorsing their application for appointment. Generally, it's this document and this process is taken up by an attorney. In all my years of practice, I don't think I've ever seen this form completed. So again, I don't know why AOC put it on there. Again, and then finally, there's an inquiry into qualifications for appointment as guardian or conservator. And that is all related to you, except for the second line. It says in re, that means concerning. And you're going to put the name of the person, of the respondent right there. But everything else, petitioner's name, social security number, date of birth, education, occupation, income, who handles the finances in your house. Do you have a checking account? Do you balance it? Have you ever had bounce checks? Have you ever been arrested? Explain. Criminal record? Explain. Bankruptcy? Explain. Rent or own your home. And have you ever been sued civilly? Explain. So that is so that we can check you out to determine if there's anything that in the system that would indicate why you're not appropriate to be over someone else's affairs. I'm at 144, and let me go directly into the explaining how this process unfolds. Once you file the petition for guardianship that we just went over, the packet in Jefferson County, and you pay the fee, it starts a process whereby the court sends out a medical doctor, a psychologist, and a social worker to evaluate the respondent and compile a report addressing the guardianship categories. And the professionals make recommendations about whether or not they believe a guardian is appropriate under the circumstances. They can indicate that somebody does not need a guardian, and that happens, you know. A lot of times it's because somebody is in dire straits in the hospital and it's looking pretty grim, and they have a really good turnaround, and it ends up that guardianship's not necessary. That's why I always tell people don't file for guardianship prematurely. But it is possible for the team to say not disabled. They can also indicate that someone is partially disabled, meaning that they lose some rights that in a particular category, but they don't lose all the rights in that category. So in some situations, we'll leave somebody with a high functioning intellectual disability the right to drive, but we'll take everything else away. In the financial categories, we'll leave sometimes on a partial financial, they will allow them the ability to manage their paycheck that they may get. Because, you know, with Social Security, you can work and earn up to a certain amount. And sometimes a partial financial guardian allows the guardian to manage the Social Security check, the bigger chunk of change, but it allows the ward to manage the little check that they get from their little job. The team members can decide that somebody is fully disabled, meaning that they lose all the rights in all categories. The right to vote is sort of off by itself, and the court determines whether or not somebody has the capacity to exercise that right, but the team will make recommendations about it. If you have strong feelings about whether or not your loved one can exercise the right to vote, you need to express that to the evaluating team when they meet with the respondent. The court won't always agree, but a lot of times they will agree to allow them to keep the right to vote if parents feel very strongly about it. If it looks like they have a capacity, some capacity to handle it. And the court can decide that somebody is fully disabled, and means that the guardian would manage every aspect of that individual's affairs, and they would not have the legal, the ward would not have the legal authority to act in those categories. When somebody has an order of guardianship, it's filed in the county clerk's office. That is the public notice to the community that somebody is under guardianship. So, you know, if your ward is mobile and sort of resistant, and they make it down to the Mercedes dealership and sign a contract and goes out and wrecks the car immediately, really address the fact whether there's any liability, because according to the law, the ward could not make a legal contract. And it's sort of on the head of Mercedes-Benz that, you know, they allow that to occur without checking it out. When the team goes out to evaluate, like I said, they compile a report. They are going to ask you for, JCPS reports, psychological reports. Don't overwhelm them with, a box full of information, but some really relevant, pertinent information, especially recent information, is something they would be interested in seeing. We're all going to get back together. Court notice is going to be sent for a hearing. It used to be that these guardianship cases had to be managed by jury trial. That is no longer the case. A hearing before the court is allowed if all the team reports are consistent and say the same thing. And I would say probably 90% of the reports are consistent. Even when it's less than a full guardianship, 90% of the time, the reports are still consistent. When the reports are not consistent, a jury trial is required. We haven't been doing jury trials during COVID. I think things are going to be starting to ramp up again here shortly, so that jury trials may start being scheduled, but they haven't been going on for the last year or so. When the hearing takes place, the medical doctor that evaluated the respondent is going to say whether or not the respondent can be in court or not. An attorney will be appointed for the respondent, a guardian ad litem. And when the assets of the ward are sufficient, these entities will be paid out of the ward's monies. If they're on Social Security, the assets are not sufficient, and the county will pay for the evaluator's assessments and the guardian ad litem, the attorney that's appointed for the respondent. Again, if the individual is on Social Security, it's not based on the parent's income, it's based on the respondent's income. So if they're on Social Security, the county's going to pay, even if the parents are millionaires. So petitioners are free to hire attorneys to help them through this process if they're confused. That's entirely up to you. And then at the hearing, on average, these take anywhere from 15 to 45 minutes. I would say that about 20, 25 minutes is the average for a hearing. And if it's concluded that some level of guardianship is necessary, the court will appoint the appropriate individual. Sometimes there's a big fight about who that appropriate individual is. And sometimes the appointment phase, who's going to be the guardian, the appointment phase takes longer than the guardianship trial. And if there is a fight and there are contesting or dueling petitions to be appointed, or applications, I should say, applications to be appointed guardian, then people probably do need to hire their own lawyers, because I, as the county's representative, do not represent any party's interest in being appointed guardian. As a matter of fact, I weigh in on whether or not I think that any applicant is appropriate. And sometimes there's information that my office has that, would impact whether or not I would agree that somebody's appropriate to be appointed. Ultimately, the decision's up to the judge. Most of the time I agree with the judge's opinions. Sometimes I don't. When I don't agree, it doesn't matter, because I'm not the judge. And the same would be true of anybody who has applied for guardian. Sometimes you get what you want and you get to be appointed. Sometimes you don't, and you disagree with not being appointed, but it doesn't matter, because you're not the judge, and ultimately the judge is the one that makes the decision. It matters, but I'm just saying it's not going to make a difference. There are going to be orders of appointment. There is a order for personal guardian, and then there's an order for conservator. And personal guardian is for personal affairs, and conservator is for financial affairs. Technically, that's not how it's written in the law, but that's how it's playing out in court. So we're just starting to separate the two. Personal affairs is personal guardian, and financial affairs is conservator. So after you get your orders of appointment, you had to file them with the county clerk. You're the one that was responsible for doing that. And normally there's a fee that they had waived during COVID, but that's probably going to start up back again here soon too. There are reporting requirements that you have with the court. And the first one's going to be the inventory. And it's due within 60 days of you being appointed as guardian. And let me back up and say this. Sometimes people are just so shocked about the paperwork involved in being someone's guardian. And I will go even further and say that sometimes they're offended by the paperwork that is involved in being a guardian. They feel like they should just be given the authority to be someone's guardian, and everybody rides off into the sunset with no oversight or accountability. Sometimes the statement, like I'm their mother, or I'm their sister, is uttered, because to them, the relationship should be sufficient to assure any and everyone that they're going to do what's best and right for their loved one. And in their instance, it may be true, but it is not always the case. It is very unfortunate that we see some really bad things, damaging situations and information that comes through our court. We frequently have adult protective services in our court. We frequently have crimes against seniors, police officers in our court. So we don't make the rules for the good ones, we make the rules for the bad apples. And unfortunately, the bad apples, the rules for the bad apples cover everybody. So as a result, there are reporting requirements to the court. The court is the final authority on guardianship cases. The court can overrule a guardian's decision in a guardianship case. And that is shocking to some people, that they can want to, take their loved one out of the nursing home, and the court can say, no, you're not removing them from the nursing home. Or we've had situations where still don't understand the reasoning, but the guardian wanted to remove somebody from a state waiver that gave them all kinds of services and benefits. And the court essentially is like, no, you're not doing that. It takes years to get on that waiver. It provides X, Y, and Z. What's your alternative solution? And of course they didn't have one. But anyway, the court can overrule the guardian. The first reporting requirement is the 60-day inventory. People are puzzled by this when their loved one gets Social Security. They're like, they don't have anything. Well, then that means filling out their form is going to be really easy. But you still have to fill it out. And essentially it's asking, do they own real property? That's land, houses, things like that. And you're going to put the value. It's asking, do they own personal property, cars, furniture, household appliances? You're going to put the value. And if they don't have any of this stuff, if they don't have any real property, you can put N/A, not applicable. Or you can put 0, but you got to put something there. You can't just leave it blank, because we don't know whether you saw it or responding to it if you leave it blank. It's asking you, are there any debts that they owe? Like outstanding balance on a mortgage, outstanding balance on a car loan, put down their debts. You're going to ask for, it's asking number 4, monies or cash on hand. In other words, what's their monthly income that's coming in? And that's A. B is, what kind of savings, checkings, and certificates of deposit do they have? Also, it's asking about claims against them, like are they being sued, or have they been sued? Is there a judgment against them? Or are they suing someone? Or do they have a judgment against someone where they're owed money? That's 5 and 6. I want to back up and talk about monies or cash on hand. If the ward has a trust fund, you're going to want to note it on here somewhere. Like if they get income from the trust, you're going to want to note that on monies and cash on hand. The court's going to want to know the value of any trust that may be out there. So that's your first reporting requirement, is the inventory. The second reporting requirement is going to be the annual report. It's due 12 months after you were appointed as guardian. And let me try to find it here. What did I do with it? All right. The annual report is informing the court of the well-being of the ward. What's changed in their life in this last year that you can update the court on. So it's going to ask what their age is. It's asking, are you the guardian, the limited guardian? Limited guardian is same thing as partial guardian. It means you have less than the full guardianship. It's asking the present age of the ward, their date of birth, where the ward's currently living, and it's asking, is that a nursing home, hospital, relatives home? What kind of situation is that? Number 5 is how long have they lived at the residence above? It's asking if they lived elsewhere during this last year, tell us where they've lived and how long they stayed there. It's asking for an update on the ward's mental condition. Has it remained the same, improved, deteriorated? How's their physical health? What's their social condition? And that means, are they still going to their day program? Do they have friends and activities that they're involved in? Or are they leading the same social lifestyle that they had in the previous year? And it repeats those same questions. Has their social condition remained the same, improved, or deteriorated? And asks for a description if it's improved or deteriorated. Number 9 is, have they received the following services? Medical care, educational services, such as, they've had a psychological report recently done, social, vocational, other. It asks what you did for the ward during the reporting period. It asks you, do you think this guardianship still needs to continue? In other words, has the ward's condition improved? And it asks you to sign and date. And again, you can do that in front of the clerk or in front of a notary. There's a financial form. The financial form is the one that probably gives people the most fits. And it is because they do not take seriously the responsibility of reporting and managing somebody else's financial affairs. People understand the concept of doing taxes every year, but for some reason, the significance of doing this financial report is not treated as, what's the word I'm looking for, as seriously as tax reporting. And I think it should, because you're handling somebody else's money. And the bottom line is you have to account to the court for every penny, every dime of the ward's money. And the way that you prove that you did with the money what you say you did on this form is through the bank records. And what that means is we need to be able to track where the money's going. So in the old days, the best method of tracking money was writing checks. And I understand that there's a modern era and electronic banking is very common. And you can write electronic checks, but it has to be to the vendor, directly to the entity that the check is payable, of course, on the to line. And then in the memo line, you need to use that the same way that you would use a physical check when you're using electronic transactions. You cannot make cash transactions when you're managing somebody else's money. You cannot get cash back. You can't go to the gambling boat on their card. You can use a debit card, but you got to keep the receipts. And you need to keep the receipts in date order. You don't have to turn in the receipts unless the court requests them, but you have to be prepared to turn them in if you're audited, if the court requests them of you. When you're appointed over someone's finances, you have to establish a bank account, a guardianship bank account. If the bank that you're dealing with will not do it or acts confused or puts you through all kinds of hoops, go to a different bank. I get calls from people all the time trying to get me to make the bank or the credit union. Usually it's a credit union because credit unions are just really bumfuzzled by guardianship paperwork. But they're trying to get me to make them cooperate. I can't do that. Their internal practices and procedures are their internal practice and procedures, and your recourse is to take your business elsewhere. But you have to set up a guardianship account, not a co-ownership bank account that allows you the right of survivorship should something happen to the ward. It isn't a payee account. It is a guardianship account. If you do not set up the guardianship account, then you are subject to being removed and as guardian and conservator, and the court requiring you to pay back monies that you can't account for. So the yearly financial requires you to list all the assets and investments of the ward. And essentially it's saying during this accounting period, what money came into your hands that was payable to the ward. And how much was it? You're going to want to break it down. So it was Social Security, then then you list that as one label. If it was pension, you put listed as another label. I always tell people that it's best to keep a monthly tracking of what comes in and what goes out. And I know the council is going to educate you on what I call the envelope system. And the bottom line is you got an envelope for every month, and then you write down the income in one column as it comes in and put the date down and the amount. Oh my goodness, my phone is blowing up. It almost makes me think something urgent is going on. And then when you spend, then you're going to write the expenditure and the date and the amount and put the receipt inside the envelope. When you get the monthly checking account statement, whether it is electronic or mailed to you, and most of them are electronic now, print it out, put it inside the envelope, and then at the end of the month, you can total up all the expenditures and you can total up all the income. Now, you're going to want to group your expenditures in categories. You just got to think about your own life. There are general categories of living that expenses fall into. You've got your roof over your head, whether that's going to be a mortgage, rent, or nursing home bill. You've got your utilities, and you've got your food. When you've got a loved one living with you, you can label that roof over your head, food, and utilities as room and board. If somebody gets Social Security and the amount of the check is minimal, you can write yourself one check each month for that figure for a reasonable amount, $600 out of an $800 check. And you can write room and board in the memo line, and the $200 that remains, you can parse out by either writing yourself a check for $200 for cash. I said the court doesn't like cash transactions, but it will permit that when it's for a monthly allowance. Because either you have to get the cash some way, or you can transfer the entire amount and call it room and board and allowance, and then you can give the allowance out of your bank account without tracking it with the court. In other words, it's not showing a cash withdrawal or a cash check transaction. I know that's a little confusing, but bottom line is try to keep a monthly envelope, and other common monthly expense categories might be, like I said, allowance. And I'm trying to think of, by the top of my head, the common ones that we see. Clothing. I think those are insurance is a common one we see, whether it's life insurance, burial insurance, but we frequently see insurance as a common monthly expense. And sometimes just miscellaneous, but you got to stay away from using miscellaneous too frequently. But the bottom line is, at the end of the year, you're going to group all the major categories and do the year totals for each one out here in the amount. At the bottom, you're going to subtract the year totals of the income. You're going to subtract the year totals of the disbursements from the year totals of the income, and that you're going to come up with the final figure of what should be on hand. This figure should really correspond to what's in the bank account as well. That figure that you come up with on your first financial is going to be the first figure that you carry over to the next financial report. And that's going to go on the first line under assets and investments. So the carryover figure from the year before is what the money that you start with for the next financial report. Again, the back asks for, how do you plan to preserve the estate? You only need to answer this if somebody has a estate valued at over $5,000. If somebody gets Social Security and that's their only income, the odds are they don't have an estate valued at over $5,000. So you don't have to answer that, and you can put N/A right there. If they do have an estate over $5,000, you're going to indicate that you're going to invest it, that you're going to continue to manage it, to whatever you're planning to do to maximize the ward's assets for their benefit is what you're going to put right there. The next two questions are about final settlements. Final settlements only need to be completed when the ward has passed away. So if the ward has not passed away, you do not need to do these next two sections. It's talk about unpaid creditors and allowed and disallowed claims. So you can, like I said, put N/A there. This form also has to be signed either before a notary or before the clerk of the court. Each year, it's going to be asking you for your phone number, and it is surprising to me how frequently that information changes. You are required to update your details and information with the court anytime it changes. Anytime it changes, immediately. If unfortunately the ward does pass away, you're also required to notify the court, and they'll tell you what steps need to be taken from that point on. I think that's it for the reports. Oh, and just really quickly, sometimes there's a problem that occurs with a situation, a case. You know, the father of the ward is acting inappropriately, and you know, refusing to bring the ward home when agreed, and you want permission from the court to stop allowing overnight visits, and the father is saying, you can't do that, you don't have the power to do. Bring it to the court and let the court hear what's going on and decide what can and cannot occur. If you're unsure about your ground, bring it to the court's attention. There are any number of motions and matters that are brought before the court. If it is of significance to the case, then the court is willing to listen and hear and decide issues related to the well-being of the ward. There are frequently times where there's a need to change who the guardian is. And there's a standard modification form that can be obtained from the clerk's office. There's a weekly motion hour where all matters that are of concern are brought to the court's attention. That occurs every Monday at 9 o'clock. Sometimes that court proceeding called motion hour lasts 2 hours. Sometimes it lasts 3 hours. Sometimes cases are so significant that we have to roll them for another day and have a special hearing for them. And sometimes those hearings can be pretty intense. So just know that not only are you allowed to seek court direction, you are required to seek court input under some circumstances. You must seek court permission to settle a trust for your ward. You must seek court permission to sell substantial assets of value. Like, you can't sell the ward's home without court permission. And if you're making a purchase over, $2,000, you need to get court permission. We see a lot of people doing things that are highly suspect. They're allegedly for the ward, but the only one really benefiting is the guardian. So, it's better to be safe and ask permission than to be sorry and have to pay the money back. You have to seek court permission to settle a civil lawsuit on behalf of a ward. So those are the overviews of the reports. I think that's what occurs to me. So if one of you all could pop back on here and tell me what the next step is, I'd be happy to undertake it.
Yes, thank you so much for all that helpful information. I don't know about everybody else, but I've been taking lots of notes. We do have some questions that were asked, so I will kind of just go in order here and ask these questions, if you don't mind.
Sure.
The first one, and it was actually, the question was somewhat given to us twice, but overall, I would say, what is the best age and time to start the process? If you've got someone that falls within that 17 to 18 time frame, like, when should people get ready to file? What do you suggest for that?
Their 17 and a half birthday minus 6 weeks. So if they're going to be 17 and a half on December 30th, then you want to go back 6 weeks from that date to file the petition. Does that make sense?
Uh-huh.
Because let me just say this really quick.
Uh-huh.
By law, we cannot appoint a guardian for an adult unless they're 17 and a half, but we sort of squeeze around that. But you can file precisely when they're 17 and a half, and the way that our court system is progressing, you'll have a guardian before they're 18, and that's usually the problematic time frame. But the question was, when's the earliest? 6 weeks before their 17 and a half birthday is the earliest you should file. But I think it's just safe to say file on their 17th and a half birthday.
Okay, I just had another question pop up. It says, what if they are currently committed to the state?
As a juvenile?
They did not specify.
If they're committed to the state as a juvenile, you need to work with the juvenile authorities to determine whether guardianship is appropriate. I will tell you candidly that if they're under juvenile guardianship to the state, then it's almost always under consideration whether or not they're going to have an adult guardian, and the state is normally appointed in those circumstances. So you've got two state agencies. You've got a juvenile state worker and you've got an adult state guardianship worker. And they have inter-office tension about when a juvenile is transferred over to the adult one, when they can be extended under juvenile commitment until they're 21. So you need to talk to the juvenile individuals to determine whether they're going to extend the commitment. If they're not, is somebody going to file for adult guardianship?
Okay, so the comment in here said the individual they're specifically asking about is an adult, and it said they were recommitted during turning 18.
So that means what I said, they were recommitted to the state until they're 21. And so no, we would not do guardianship while a juvenile is committed to the state. They serve the same function. The state under that's over a juvenile guardian acts as a parent, so they don't need guardianship authority. They already have all the authority they need under juvenile law.
Got it. So even if a individual is unhappy with their current placement, that doesn't change, or would they give the right to petition that at that point?
I mean, there can be talk about terminating the state juvenile guardianship, but it is redundant to seek guardianship when there is a state juvenile guardian, and because they're literally the same thing under different umbrellas, the same thing. So if they're dissatisfied with who the state juvenile guardian's worker is, they need to address that interagency with the agency. And I'm not sure that it's going to be changed, because the agency's in charge and they get to decide who their workers are that are assigned to the case. You might go to Protection and Advocacy. They are a group in Frankfurt that looks into situations for vulnerable citizens and to make sure that their rights are being protected when they're under state agency purview.
Okay, another question is, if an individual already has a functional capacity exam, should they send that in with their petition when they're originally filing the paperwork?
You want to be very minimal with the paperwork. So if it's a 5-page report, sure, send it in. If it's a 50-page report, no, don't send that in. You can keep it on hand for when the evaluators come meet with your loved one and show it to them. But yeah, small bits of paperwork can certainly be added to the petition, but not, the clerks just don't want, tomes filed with the clerk.
Another question is there information that would, and you kind of touched on this, that someone could be proven to not be a good guardian? So I guess, for example, say someone has a guardian and that individual has gotten multiple DUIs or something like that. Should they submit that information? Is there a number that they call? How does somebody go about petitioning or letting the court know about those situations?
Yes, and you're right. I did talk about motion hour. Motion hour is where that kind of thing is brought to the court's attention. You got to be careful about what you put on motion hour. First of all, the process of getting something on motion hour is I drew up a form many years ago. It's a blank form that the clerks can give you. And it essentially says, whose case is this about? It's the ward's name. Who are you? And it gives you a bunch of blank lines. Tell us what your concern is. And you just write it out in your own words. Now, I hope people appreciate how significant that is. In Indiana, you cannot get to a court without a lawyer. So the fact that we allow people pro se to walk in off the streets and just tell us stuff is a huge benefit in our system. But when you do tell the court stuff, you can't tell the court, I don't like him. I never did like him. I don't think he does a good job. You can't just give us your opinions and your feelings, okay? Our courts are fact-based, and facts are what you have seen with your own eyes, heard with your own ears, or producing the other people, the witnesses that have seen with their own eyes or heard with their own ears, information that is detrimental to the safety, health, and well-being of the ward. So yes, you can present that, but it's gonna be a hearing. They're gonna have the opportunity to refute it and present witnesses as their own. So it's not just a matter of you coming in and telling the court, they acted up, they did bad.
Gotcha. Okay, one of the comments on here is, it says, I work with Michelle P. Waiver. Sometimes we have difficulty getting the reports from the doctors, social workers, psych, etc. for hearings. Does the guardian get those reports automatically, or how does that work?
If you're referring to the court, the court's reports that are compiled for guardianship, they're confidential. No, they are not automatically released. Nobody is automatically entitled to them except for the prosecutor and the guardian ad litem, the attorney for the ward. Most people, when they need them for waiver purposes, will request them at the hearing, and the judge will release them on the record. But if you wait to request it, yeah, you're gonna have to go through a hoop, putting it on motion hour, and requesting it and waiting for the time for the hearing to roll around. So it's best to ask for it at the trial.
And if you ask at the trial, is there a separate release of information or anything involved, or?
No, just requesting of the court, and the court will instruct that you cannot share it. It's literally for a limited purpose, because it's confidential. So if you're going to give it for proof of need of Michelle P. Waiver, that's the only entity that you're will. So in other words, when you give it to them, you almost need to destroy it.
Got it.
It's, I see these reports all day, every day. I don't think that they have any information that's more, what's the word I'm looking for? Private than a psychological exam by JCPS, but the statute says they're confidential, so.
Are there any programs that assist individuals that have trouble trying to pay the $100.50 for the filing?
The $100.50 is meant to be paid out of the ward's assets. So either the ward has the money or they don't, okay? Now, if they do have the money, but you don't have access to it yet because you're not guardian, you can loan them the money, and then when the guardianship is in place, get reimbursed immediately. But if the ward doesn't have the money, like I said, you can, well, if nobody has the money, you can ask to file what we call an informal pauperous form and saying, I can't afford to file the waiving, file the fee. I can't afford to pay the filing fee. So would you waive it for me? And it just depends on what you put on that form as to whether or not the judge will do that.
Okay. This person had commented that it looks like she said, I'm not understanding the answer. Her son had turned 18 while in the state custody. So now she's trying to get guardianship to remove him out of that commitment. And it looks like, because of COVID, said I was granted PC back in 2013. But it looks like now, because of COVID and everything, there's been an issue with that.
Well, let me interrupt and say that her situation is not a straight guardianship case, okay? It is not the typical scenario that I see when I come speak to the council. Hers is a special niche circumstance that, one, she either needs to hire an attorney to address for her, or two, deal with the agency that has that has juvenile, what do you want to call that? Juvenile authority over him. I cannot, let me put it this way, if the petition was filed in Jefferson County, I would not approve it to go forward because he's under juvenile guardianship. I don't know that guardianship has any, unless she's in another county. I'm speaking for Jefferson County. I approve the petitions to see if they're legally sufficient. And what I would say is this a less restrictive alternative of juvenile guardianship exists. So I would not allow that petition to go forward. So in light of the fact that it's not appropriate for guardianship, I'm not sure that I can help her.
She said she's hired an attorney, but he is now 18. He turned 18 while he's been in their care.
His commitment was extended until he's 21. So 18 is not the magic number.
21 is the magic number.
Okay.
Another question we have is on the reporting form. It looks like I guess it's number 4. Is that where you would list a stable account as well, if an individual has a stable account?
Number 4 on the financial report.
So this would be your
Inventory.
60-day inventory form, the AOC 855.
What's a stable account?
It's similar to a trust. It's just where there's a ward like over the account and the monies are still monitored just in a different way. But it's set up to the kind of by the government. So for example, if an individual had X amount of money and their guardian chooses to put it in a stable account and then they pass away, then that money, if they still have outstanding funds from SSI, that money goes back to SSI, if that makes sense.
Yeah.
It's like a protection fund, really.
Right. If there's money that's for the benefit of the ward in some way, or comes in their name, it needs to be listed. And so yes, number 4 looks like it would be an appropriate place to put that.
Okay. It looks like there's another one down here in a different section. It says, if a 17-year-old will be turning 18 and do not and will not have income, SSI, etc., do you still need a banking account and a bond?
No. Bank accounts are meant for incomes received. So if there's no income received, you don't have to open the bank account. But the minute you get that first check, yes, you need to open the bank account. And you wouldn't be bonded. Okay, let me put it this way. Bond is required no matter what the circumstances. So generally, the court would put the bond at some minimal amount, like $1,000 without corporate surety, since they have no income. And then they would tell you, please come back and let us know immediately when they start receiving income so we can modify the bond.
Okay. Let's see, here is another question. What number should someone call to report information change? Is there a number that they should call, or?
Mental health clerks, 595-4053. That's their main number. That's the one I was looking for and saying that I thought it was printed on the paperwork, but I don't think it is.
Another one is, what is the standard form to change the guardian? What number form is that if someone needed to request it?
Petition for modification, relief for modification, AOC 795, but we usually go by the name. The clerks really don't know the numbers. I, as an attorney, know the numbers, but you're gonna say, I need to change the guardian, and can you give me that form? And the clerks know exactly which one that is.
Right, does anyone else have any additional questions? If you do, please raise your hand. I can unmute you, or you can type it in the chat. And also just to share a little bit of additional information, the council can help assist in the completion of these documents. We do not do them for you, but we can coach you in, providing some template examples. So if you are not sure where to write something, we can kind of give you a visual to help along. I know sometimes that is helpful for people. I tend to like YouTube for that exact reason. If I don't know how to do it, I watch a video. So for anybody else like that, we do have templates that will help you. When it comes to the envelope system, we're actually making a video for that reason. So we will have a video posted on our new website that will walk you through, show you exactly what that looks like. So stay tuned so you can see that as well. It looks like another question came in. It says, how can we get access to the recording of this session? So this session will actually be posted on our website and on the council's YouTube page.
Oh, well, my goodness.
So you are going to be a celebrity, Miss Claudia, but then that way you've got a option to go back and watch this again later so that you know how to answer this. And again, if anyone has questions, feel free to call the council. We do have a disclaimer that we are not attorneys. That is Miss Claudia's job. She does that awesome all day long, but we here at the council are not. So we can give limited answers and resources, but we do know that this is a very lengthy and can be confusing process. So we want to help as best we can. So we can provide examples and videos, but any actual attorney questions, you will need to seek attorney counsel for that. So.
And I know that attorney is part of my title, but a lot of people don't know that prosecutors are lawyers too. So I am a lawyer. I don't specifically give legal advice, but if you have a question, the clerks generally won't give you more than superficial assistance because they're not lawyers either. They frequently refer you to our office. So I am here to try to help, but sometimes I do have to refer you to private counsel.